Good morning, sir.
Good morning, madam.
So, shall we start?
Yes, ma'am.
Participants are okay. Good morning, everyone. I hope all are set for the today's session. Myself, Jyoti Chaudhary, BSc ITCS faculty at NMFC College. I welcome all to the last day of our series, that is on fifth day of 5 days national level FDP program on enhancing quality research through a patent writing and IPR organized by Computer Science Department of Nirmala Memorial Foundation College of Commerce and Science, Maharashtra in collaboration with Loyola Academy, Telangana. So our today's session walks through on drafting, filing and commercialization of a patents. So now it is indeed a privilege and an honor to introduce the distinguished academician and accomplished researcher and a visionary in the field of biochemistry and plant sciences, Sir Dr. Ravi Kiran Surupedi. So Sir has completed. Now let's have a look on Sir's achievement. Sir has completed his master degree in biochemistry from Acharya Nagarjuna University, Guntur in 2000 and later earned his PhD in plant sciences from Osmania University in 2006. His extensive research spans over 17 years, covering areas such as natural products, herbal medicinal formulations, analytical method development and validations, and enzymology. Sir's contribution to the scientific community are commendable. He holds 2 patents and has published 42 research papers in esteemed national and international journals. His scholarly contributions also include 7 review chapters in edited volumes and presentations of around 32 research papers at various national and international conferences. Furthermore, he has co-authored 9 books covering subjects ranging from biochemistry to environmental sciences and research ethics, with 5 volumes dedicated to biochemistry for the BSc curriculum of Telugu Academy. So beyond his own research and writing, Sir has been instrumental in shaping the academic landscape through his role as a journal referee and the editorial board member for reputed journals such as the Journal of Advanced Research, 3 Biotech, Medicinal Plants, International Journal of Phytomedicines, and several others. So, a true leader in academia, Sir has organized 12 national and international conferences, 5 faculty development workshops, and 3 student research workshops. He has delivered 10 invited lecturers at prestigious university across India and serves as a board of studies and board of examiners, members of biochemistry, biotechnology, and microbiology at various institutions. So his expertise has been instrumental in designing the CBCS syllabus for both undergraduate and postgraduate courses at Osmania University. So his excellence has been recognized with numerous accolades, including the Associate Fellow Award from Telangana Academy of Sciences, the Best Faculty Award from Nehru Group of Institutions, the Teaching and Research Excellence Award from Chennai, and the international recognition such as the Research Excellence Award from I2OR in association with Western University, Australia. He has also been honored with the Best Senior Faculty Award by Nobel Research Academy, Puducherry, and multiple Best Teacher Awards from IMFR and I2OR. Currently, Sir is serving as an assistant professor in the Department of Botany and Food and Nutrition at RBVRR Women's College, Hyderabad. Additionally, he holds key position as the director of R&D, as a NAC steering committee member, and a member of IQAC at the institution. Through his unwavering commitment to fostering research culture among young scholars, he continues to inspire and guide students to present their research findings at prestigious conferences and seminars across the country. So everyone, please join me in welcoming a remarkable educator, researcher, and a mentor, Sir Dr. Ravi Kiran Surupedi. Welcome, sir. We are honored to have you here and ready to hear from you. Over to you, sir.
Thank you, madam. Thank you for introducing me. So, very good morning to one and all. And first, I thank the organizers, that is Nirmala Memorial Foundation College of Commerce, and Science, Mumbai, Maharashtra, and also Loyola Academy, Telangana, for inviting me as a resource person for this 5-day national faculty development program on enhancing quality research through patent writing and IPR. Is my screen visible, madam?
Yes, sir, it's visible.
Sir, now, because I kept in slideshow mode,
Yes, sir, it's visible.
yeah. So coming to IPR, I think you must have, all of you have, the eminent speakers might have given an insight into the patents and what are the different types of patents and all. I just give overview of that and then we'll move on to drafting. Now, all of you know, patent is a right. Actually, what I said is statutory right. To whom? To the inventor. So it is a statutory right to the inventor or the one who applies, what we call applicant. And either Indian or foreign authors, whoever it may be. So it is a right to the inventor or the applicant. The right is basically for his or her invention, which can be either a process or can be a product. So it can be a process or it can be product, and the right is given to that particular person or inventor just for a stipulated period of time, maybe 15 years or 20 years, maximum 20 years of time. And what happens after 20 years? After 20 years, our patent or the invention, it goes to the public domain. And within this 20 years, only we have right to use, to manufacture, to make, or to produce whatever you say, to license everything. But after 20 years, we are going to lose the rights on the patent and it goes to public domain. And once it enters public domain, anybody can use your invention. So before that, we have to open up our eyes and we have to make licensing. I'll tell you the commercialization process also. Now, so it is for 20 years. Now, the importance of this is, suppose if you are working on any research area, on any topic, and if you find any novel or significant findings which are novel and not yet published anywhere across the globe, what I suggest is first you go for patenting. But what we do, Indians, we do mistake that we go for publication. Research publication anyway in lifetime we can publish, but that is not a criteria. First go for patenting. Suppose you got a new process or a new product you have with significant, social, societal impact or significant contributions which you can bring about in healthcare or in any other sector. First you go for patenting. That is very important point. But what we do, we only do for publication. So better go for patenting. Then once you go for patenting, we have filing. I'll tell you how to draft, how to make it everything. Now, why I'm telling go for patenting, that you have a right on that because it is a new process or a new product you are bringing out to the market. Now, once you register that product or process, you have every right such a way that right prevents the third parties, okay, by using, by making, manufacturing, or by selling or by distributing, importing, whatever, licensing, everything. So all rights will be given to the inventor only. Now, once you like take a license, that is on your name. Now, this is advantage of having a patent rights on it. Now, you know this nature of IPR and which can be patented, which cannot be patented. Now we have different types of designs, the patents, trademarks, geographical indications. Okay, we have some designs and plant varieties and also farmers' rights also. Okay, that will I think almost by covered by previous speakers. But if you see a overview of these IPRs, so which can be patented, and there are certain areas where we cannot take a patent also. Now, what can be patented actually? You can patent an article, you can patent an apparatus, good. You can patent a machinery or a component of machinery which is inbuilt. Then a substance, I mean product, what I mean to say, a product. So it can be a pharmaceutical product or any other industrial product also. Or it can be a process. That means all the existing process is there. You can modify the process so that you can make it an efficient process, a rapid process, or more efficacy with more efficacy, more efficient one. Okay, so all these can be patented. Now, if you talk about the copyrights, so we have certain plant varieties, we have certain electronic components, the designs of that. So you can take a copyright or some related rights on that. Then we have trademarks. So you can design a logo and you can take a trademark. Then you have geographical indications that we call territorial rights. Suppose best example is Sholapur, that blankets we have, Sholapur, the chappal we have. Then we have certain mango varieties where we can grow only at certain particular places. Okay. So these are geographical indications. Now I'm residing at Hyderabad. I cannot take a geographical indication patent on that Sholapur chapels or whatever available across India. So the people who are residing in that geographical areas are only allowed to take rights or patents on that particular items. Now, like we have designs, we have patents, we have trademarks, then we have trade secrets, geographical indications, Kolhapur chappals, Nirmal paintings, Pochampalli saris we have in nearby Hyderabad, we have Pochampalli saris. That is geographical indication. No other person other than Pochampalli can take a right on those saris. Like we have Lucknow chicken work, that is famous Lucknow chicken work. So only the people who are residing at Lucknow can apply. And each of these trademarks or patents, it varies from the rights given to a people varies from 10 years to 20 years. Then beyond which what happens? So after 10 years, by request, we can apply to a patent office for extension of our rights. And at the most, they will sanction up to 5 years license for it. I mean, the rights on that particular indication or particular secret or particular. But exclusively patents, if you see patents only for 20 years. Remaining all varies from 10 years to 15 years or some 7 years. Okay, ranging from trademarks, you'll be giving only 7 years of time. Then after that, again, we have to go for registration. That registration again depends upon that patent office, whether they can sanction or not. That again depends on that particular application process. For geographical indication, you'll be getting 10 years. 10 years. But after that, again, they have to go for registration process. Okay, and again that depends on so many application process. It went it through with the process that valid for another 5 to 10 years will be given. Now Darjeeling tea, I forgot to mention. Darjeeling tea is one of the geographical indications. Now Ooty tea also is geographical indication for us. So like that. Then we have copyrights. So copyrights, we have examples, like best examples, Bhagavad Gita and Patanjali Yoga Sutras. Patanjali, this copyrights has been given to Patanjali Yoga Sutras only. Now we cannot copy and paste, and we can obtain, the rights for that. There is no, such a provision made there. Then these are the registered ones, and we have unregistered ones. So registered IP rights includes only three categories. One is patenting, one is trademarks, and third one is designs. That's all. And remaining all comes under unregistered IPRs. Though they are unregistered, what I meant to say here is, though they are unregistered, so the people who are residing in that particular area for geographical indications, and the farmers who are going special varieties of plants in that area, they are only eligible for that areas are only eligible for the rights on that IPR for that. Then we have copyrights. As copyrights are unregistered, though they unregistered, but if we violate, there are people can sue on other person who have copied from that. Suppose if I'm copying Yoga Sutras from Patanjali, so Patanjali people can petition, give petition, file a petition on me, and I need to face the music. So this is what we, but though they're unregistered, we don't have any right to copy, to reproduce, to reapply for any rights on that. Now, suppose say you have a patent. We want to patent it. What is the basic criteria? There are only three criterias, basic three criterias where we can patent it. One is novelty, then non-obviousness, and the third one is industrial application. Industrial applications. Now, if your work meets all these criterias, then we can go for a patenting. Now, I just move on. These are all I think already might have discussed. Now here, if you see, we have different types of patents. We have utility patents, we have plant, then we have designs. Like a jewelry, you can make a new design. Yes, you can apply for a patent. A decoration, you can make a patent. Now apparels, now we have Bandhani cloths or Lucknow chicken works. So these are all patented on that. So these are all patenting, design patents. That's what I said. If it can be a novelty or non-obviousness, which has industrial application process. Now, non-obviousness, it should be non-obvious because to a person skilled in the art to which the invention relates, that should be non-obvious. So these are the three criteria. And if if you see that your work meets all these criteria, yes, first you go for patenting. Now I'll move on to the drafting. Now I just move on to drafting because all these are might have discussed previously. Now there are specifications in that drafting. I'll just show you. Sorry, I'm just skipping the slides. Now, this is a patent specification. Now, when I say, I train so many, I already trained students and faculty also in writing a patent, because don't look at, rocket science. It is very easy, like how we write our manuscripts day in, day out, the publication papers, that like that same manner, we can write a patent also. It's very easy. I'll make it easy for you people how to write a patent. Now we have two types of specifications in a patent. One is description, that complete specification comes along with claims. Now we have to claim what we are claiming from our process or uh, product or whatever it is. Now these claims have to written very carefully, and it should cover the entire research of that particular patent. Suppose if you are not giving a claims properly, some other person might claim again and he or she can take a patent rights on the same one. I mean, a different one. So it's reinventing the wheel such a way that. So we must be very careful in giving a claims. I'll show an example of writing claims also. Now coming to description, where it involves the entire process of your invention. Entire process of your invention. Now see here, description. You must describe your invention very comprehensively, such a way that no other, the referee should not question you again back to back. That's why discuss the entire invention comprehensively and explain your problem and the solution with suitable examples. And third point, very important, there should not be any ambiguity. So there should not be, the writing should be such a way that, very clear, concise, and there is no ambiguity. Please avoid beating around the bush. Now, the fourth one point, if you see, the description should be adequate and sufficient so that it gives the entire picture of the invention. So it should discuss the novelty, the non-obviousness, and also the application purposes. That is what. So as to enable a person skilled in the art to perform and repeat the invention without inventor's further inputs. Suppose you are describing everything and you are taking a patent. Suppose if I take a license from you and if I want to repeat the process, okay, or if I want to use a product, or if I want to use your rights something, and I must be able to use it properly without interference of yours. So I should not keep on taking again inputs from you people. So you have to write such a way that everything is clear and concise. And your description should reflect the novelty, the invention, applications, and also the patentable under Indian patent law. So there are certain, objects which cannot be patented that should be avoided. Then see here how we describe a manuscript. Same way we can write our patent also. So there are certain contents in the patent description. So first the title, which should be concise or precise and accurate, and describe the entire invention. Then the second one, we have field of invention. The third one, background of invention. And the fourth one, prior art, where we describe everything. Then we have objects of invention, the statement of invention, detailed description, and finally we come to claims. We'll see one by one step. Now the title. Now when you keep a title for a manuscript, same title you can use it, but it should be short and crisp. Okay, short and crisp. So there should not be 2 lines, 3 lines, 4 lines, nothing, not like that. A single line title, which is very short, concise, crisp, whatever you say, which describes the entire patent research work of the patent. You should be such a way design a title for it. Okay. Then, like see here, like this, brush versus a cleaning article. Suppose you're writing like that, or a pen versus a writing instrument. You can make it, or an a patent. I mean a pen with more novel, more a pen with more writing efficacy, or more ink efficiency, or more nib efficiency. Like that, you can design a title short and crisp. Then field of invention. That is how you are opening the like how you open a paper with an abstract. Here also, abstract nothing but a field of invention. Abstract also I'll tell you. So this field of invention where we are giving more details, like what is a research about, what is a patent about, what it discuss, and shortly what is I mean the significant application, significant results obtained in the patent. Now the background, so provides a technical background of invention. I'll just skip. See, I'll give you a clear claim on this. Now, if you see here, I'll I'll just tell you. Now, see, these are some of the basic, titles you could make. Title, background, summary, brief description, elaborate drawings, claims, whatever it is. Now, what is the title? As we discussed, title should be concise, should be accurate, and should reflect the invention. Then you have to provide a concise abstract, the summary of your invention, like how you got, the significant results, okay, and uh, significant results of your research along with importance of your research that you want to discuss in abstract. Now the background or the field of invention, what we say, both are same. Here, which field your research belongs to, and nothing but like how we do review of literature in our manuscripts. Similarly, you have to do review of literature, and those review of literatures have to be presented in this uh, 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 context, like background and field of invention. Now discuss what is the existing literature, what are the gaps or the limitations existing in the given literature. That is field of invention and background. Then later on comes the heading summary of invention. You are going to give the summary of the entire invention what you made. Now, a concise overview of invention's main components and how they interact to solve the problem have to be discussed at this point. Now, in the some background, what we're giving the literature along with the gap, and that gap, how your patent or the research addresses, that is nothing but the summary of your invention. Then comes the detailed description. And as we say, like the methodology or the results and discussions, what we say, the results and discussions and methodology in the manuscript, results and discussions are heart of the manuscript. Similarly here, the detailed descriptions, we call it as heart of your patent. So it should be more clear, more detailed. You have to explain along with the examples, the tables, the graphs, whatever it is. Okay, everything that technically you have to present more clearly and more detail. that how we present in results and results there in manuscripts. Similarly, detailed description involves all the areas, like you can talk about tables, the graphs, the figures, pictures. So everything have to be included, incorporate in that, and also describe the each and every table, each and every results what you have obtained in your results in detailed descriptions. That is what we called as drawings in patents. Drawings nothing but your flow charts, your tables, I mean your pictures or illustrations, whatever, so on and so forth. These are good. Now coming to claims, next last part. So claims are nothing but you are clearly giving a boundary for your patent, such a way that no other person, the third party, enters into your patent. Suppose if you leave any of the part of the patent, yes, I can come into the patent, I can grab your work, I can take your patent rights because you have left that part in your patent. So I can claim, I can again apply for a patent, so I can utilize your patent. That's why these, when you're giving these claims, is very crucial in your application process, so that you give a claim in such a way that the entire patent rights are being protected by you only. You are not giving any of the rights in the given area of research to the other person. This is what we call a claims. So we have to limit the complete, boundary so that nobody can enter into your boundary. That is what a claim is. Now, these are some of the clues what I gave, I mean, tips while writing, like how we give tips for writing manuscripts. Similarly, we can give, tips for writing a patent. So here, first point, it should be clear and specific language, and don't use jargons. Okay, don't use jargons. Please avoid jargons, and also some technical terms which might not be universally understood. There are some jargons and some technical terms what we specify on our own that should be avoided. Wherever the technical terms which is applicable universally across the globe, those technical terms have to be used. You can use it. Then enablement and the best mode. What is enablement and best mode is nothing but, how the description lies. Whether you are giving a detailed description in a better manner such that nobody can enter into again the description, and give such a way the description, your patent will be accepted. Okay. And based on description, your patent will be accepted. Otherwise, your application will be rejected. Okay. Rejected. Then the third one is inventive step. So there should be some invention in your patent, then only we can able to apply for that process. And that invention nothing but, it's a novelty or uniqueness. Whatever may be a process you design or a paid product you bring out, that should be unique. Unique. Don't try to reinvent the wheel. Suppose already existing process is there. If you can try to improve the process. Say, for example, you have designed a process already existing in the market. Say, for example, making a product of some X product. So it is taking, say, for example, 5 days of time with a yield of, say, for example, 70%. Fine. But I can design a process. I can modify a process. That means a new process where it is rapid and efficient. Rapid in the sense I can, if it takes 5 days for you, it is taking only 1 day for me or 1.5 days for me. And you got 70% yield but I can produce 90% yield. Yes, that my process can be patented. So it's a unique process is unique, and also product, some of the products may also be unique. So that inventive step should be there, and you just put more focus on the inventive process or emphasize more on this inventive step. Then thorough search. Now, prior art search, nothing but review of literature. Now, before drafting a patent, now how you do literature survey before writing a manuscript? You have to do thorough research in a patenting. So there are several websites in government patent websites. We have Indian patents, Indian government websites. Okay, Indian Patent Act we have. Then Indian patents, we have Europe patents, US PTO, US patents we have, Australian patents we have, African patents we have, so many countries. And suppose you are making a patent, it's a new product or new process. We know that that is unique, but still we have to do prior art. That is very important. Better search in all the countries' patent government websites are freely available. Just search in that whether someone might have designed or applied for a patent, got a patent on your process or patent. That is very much important. And this prior art search, okay, you have to do such a way that all government websites you have to search and ensure that no process or patent on, on your product or process has been applied. Then immediately start writing and immediately apply for this application. You go for filing. I'll tell you filing of patent too as well. Okay, this filing immediately. Don't delay. Maybe someone might be they steal that. That's why before someone does, you just do file a patent immediately. Then you can take professional assistants. We have certain patent agents on a patent writing agencies now. So many people are there, and now people are utilizing all these. You can utilize them for your any assistance required in writing and filing a patent. Now, these are some of the points where we won't consider while drafting, like an essay or a business plan. Yes, business plan cannot be patented. You cannot take even a right on business plan too. There are no rights, no registration, no unregistered, nothing. No rights. Business plan is open. Until you apply for a trade secret, until you get a product and you apply for a trade secret, your business plan is nothing. No, that is, we cannot take anything into consideration. Then, now if you see the research or invention described previously as being congruent with established journals, papers, no, that also cannot be taken into consideration while drafting. You won't get your patent if you apply in all this. Then some of the points, if it is inappropriate, application, then also your patent will be rejected. Then if the application is not proven by you, that then in that case also it can be rejected. Then if the technical specifications are weak in that particular process also, your patent can be rejected. So finally, if you see, better you give your patent, you draft it such a way that is technically strong, and none of them technically strong, then novel, none of them have taken across the globe, and then finally you can apply for this. Now, this is one of my patent. We have like we have given a product that mosquito repellent using plant products. Okay, plant products, mosquito repellent activity of a particular product. Now, once I did research on this, then immediately we have I've searched prior art, and this prior art it took me almost 1 month time, 1 month. Every day I used to sit on all the patent offices. I used to check all the websites, whether it has been published or not. Then I came to conclusion that it has not been published. Then we went to writing a drafting a patent and filed a patent. Now this is a short and crisp abstract, which is almost 100 words. It should have been not more than 100 words. Your abstract should be maximum 100 words. Okay. So you just describe what this invention or investigation you're facilitates. Okay. Then what are the significant result of this? That's all. That is enough for an abstract. Then this is the field of invention. So this is field. What field? Now my field is innovative herbal mosquito repellent. Innovative herbal mosquito repellent. That is the area where my field of invention lies. Okay. Then what is the background? As I said, I've quoted some of the patents and literatures. So this is background of invention, or you can say prior art also we can say. Okay, you can quote all the literature, existing one, and what are the gaps in that. Not only quoting, we have to give the limitations of this. Limitations. Then this is the brief summary, address how the gaps can be addressed in your brief summary. Then claims is very good. Claim is very important, where we claim completely. I've set boundaries for my patent that I've claimed six claims pertaining to that, entire research work, such a way that no other third party can enter into my product. Okay. So I will claim such a way that now see the claims comprising a plant oil. Okay. So where we have used leaves, then comprising the fresh leaves, then how much percentage, then what people are using, how people are using, then so this is suitable for repelling mosquitoes. These are all my claims. So claims should be very now detailed description involves your methodology, how you have carried out your work, then the tables, the illustrations, then with examples. Okay, detailed examples. I don't think I gave examples. I just because it gives a lot of examples, nothing but the methodology how you have done for each like how you do like assessment of some work. So that assessment you have to discuss with examples how you got the result. So that is what detailed examples. So this is what how you draft a patent. Very simple, like it looks like our research articles, but only thing is we should be very careful in prior art, and it should be technically sound and with novelty and with suitable examples. We have to describe our invention. And if you write like this, as good as that, as simple as that, you can go for filing a patent. Then, sir, when anything, queries, you can please, talk about this with respect to drafting. Anyone you can post in the chat box. Organizers. Organizers, am I audible?
Yes, sir, you are audible.
Hello. Madam, is my screen visible, madam?
So I guess it's a stop. You have stopped the sharing because it's not visible now.
Just 1 second, because some technical issue I faced now just now.
Yeah, now it's visible, sir.
Okay. Now, how to file, a patent? Once the drafting is done, we can go in file our patent in two modes. One is physical filing, and other one is e-filing. So physical filing and e-filing we can go. So physical filing is we can visit any of the patent offices. So these are some of the patent offices. One is located in Chennai, Mumbai, Delhi, and Kolkata. And respective states, I've listed down the territorial jurisdiction. So the AP, Karnataka, Kerala, Tamil Nadu, and the Union Territories of Puducherry and Lakshadweep. So these people, they have to go for Chennai Patent Office. Whereas Maharashtra, Gujarat, MP, Goa, Chhattisgarh, and Union Territories of Goa, Dayu, Daman, Daman, Dayu, Dadra, and Nagar Haveli. So they are allowed to go for Mumbai office, where you can go and file a patent. Then we have New Delhi, other states like Haryana, Himachal Pradesh, Jammu, Kashmir, Punjab, Rajasthan, UP, Uttaranchal, Delhi, and Chandigarh. So all these people are allowed to go to New Delhi office. Whereas the rest of India, the other states can approach the Kolkata office for getting application forms, and the filing. Everything can be done at the respective offices. Right. Now, if you go to any patent office, they'll be guiding you, they'll be giving physical forms. You can try to fill the forms, and you can enclose your patent. You can submit in the patent office directly. Or no other way, we can go for e-filing. So in e-filing, I'll show you these documents. Like everything is available online. We have a website called ipindiaonline.go.in, where you can browse through it. You can get application forms, each and every form I'll show you, and you can fill the forms, and you can submit through online only. Or if you want to go offline, you take all these forms, printouts, you can fill the forms, attach your patent, you can send either by post, or you can approach directly patent office, additional controllers. We have controller of patents. You can directly submit in your respective patent offices. Now see, it's a general procedure. First, you have to file a patent, an application for it, then publication after 18 months. Now here, what I suggest you people, we have two categories. One is patent publication, other one is grant. Other one is grant, patent grant. Now, patent publications, there is no value for patent publications. Nowadays, we have NAC, NIRF, everything. In all these cases, patent publications are not considered. You have to go for a grant in it. You have to go for grant. Once the patent is granted, that get a granted patent is valid. Patent publication is not valid. Now, one more thing I want to suggest. I've heard, I don't know, there is a misconception as well, but I've heard there are certain agents who are, minting money. Okay, not government of officials. There are certain private agencies. Okay, consultancy services. They are minting money. They are attracting people like that. We are going to give patent publication, and they are charging 10,000 rupees, 20,000 rupees from each and every author. Okay, and my request is, please don't fall under prey of those uh, you know uh, uh, hopeless consultancy people. Please, if you want any patent, please try to work out. You try to invent, you try to design or whatever it is, better go on your own. Okay, and though that 10,000, 20,000, whatever they are charging, that is only for publication purpose. And that publication is mere waste for academic purpose. Even for industrial use also nothing, that is useless. Better go for grant, and that grant they will not give for 20,000 rupees for you. They're simply giving publication, and that publication is not at all valid, and you are going to lose your money 20,000 rupees on that. That's why please be cautious on that. Okay, though this record meeting is recording, I want to tell to all the people. Okay, I want to tell all the people, please be cautious. Don't ever fall in the prey of those consultancy people. Better you try to work on this. Now, after, publication not necessary for us. We'll go for again request for examination. Now, once we put up a request for examination, yes, it will go for examine by reviewers, and then they go for grant. Okay. Now, see here, request for examination, then what happens? Grant or refusal. Yes, refusal. Once they refuse, they'll give the patent is, your application is rejected. Fine. Suppose if your application is good enough, meeting all the criteria, they go for grant. Okay, publication of grant of patent. Then publication of grant of patent. That means that patent is granted to you. That is what important for us, not the second step. Okay, 3, 4, 5, 6. Sixth step is very important for us. Second step is useless anyway. We don't require anything. We want only grant of patent. Now, once it is granted, now post grant opposition may also rise by one of your inventors. Now, co-authors will be there. Okay, see to that there is no opposition from that. Once there is no opposition, so your patent is granted. Suppose if one of the co-authors of your patent opposes, control question whether to reject your reject the opposition or accept the opposition if I reject your patent grant. So that is very crucial. That's why see to it, all your co-authors belong to your own lab, your own lab. Okay. Now the patent applications, what the consultancy people are giving. Okay. One from Hyderabad, myself, suppose say myself, one from Kolkata, one from Nagpur, one from Kota, one from Puducherry, one from Manipur. No link. We don't know each other faces. We don't know which other who we are. We don't know what is what. But I'm paying 20,000. I'm getting the patent publication. That is mere useless for me. I can't claim in my CV, and I can't claim to the college also. That's why please be cautious. Go for only grant, not for simple publication. Okay. This is my sincere request. I'm folding my hands and requesting, please we follow the procedures. Now, these are some of the techno-legal documentations. Okay. And legal information, that's what I said you. Don't assign. Suppose you are working on your, okay, suppose I'm your friend. Friend is friend. Don't put my name in your patent. Okay, suppose I can go for opposition law later on. That's why you yourself, because you are the inventor, and the students or the faculty or persons who are working with you in the same in your lab in the same area for you, those people have to be there in a uh, uh, patent. That's why legal information very important. Your name, address, the contact details, inventors. Okay, then everything should be given properly in proper one. There is a form 1 available. In the form 1 you have to give all these details, whereas form 3 is available. Form 3 is nothing but your assignments and also details of foreign filing. That suppose I am going for another filing in outside India. So I have to give the details. Suppose I am applying for US patent. So I have to give US patent filing right, all that information. Then form 2 is available where we give all our applications, all like what we discussed, the draft, how we made, like from abstract, a title, abstract till the claims. Everything should be given in form 2. Okay, in all these we have to give. Then we have request for examination. So form 18 we have. Then request for early publication, form 9, and power of authority if assigned to patent agent. Suppose you are applying through a patent agent, we can give power of authority to him or her, so that so they're authorized to go ahead with the other like uh, question answer sessions, everything they'll be taking care of in the in between review process. So this is what technical legal document includes. Now this is what a graphical presentation of your patent grants. Okay, patent application, then publication. Now all these consultancy people, why I'm telling, they they can go up to publication, the first step only, because they don't know what is what next level. That's why they go only for publication level. Okay. So some other people like this, we don't know each other faces. So they'll get 20,000 rupees. They'll put your name, my name, some other name, publication we got. We cannot show in our CV. We cannot show in the college house. Waste. Then once it go, then pub examination. Once it go for examination, we'll get an application for grant. Then we apply for a grant. We'll get a grant. That means all rights are reserved for us. Okay. Now these are some of the steps involved. So we can file a patent, where to file a patent, and how to file a patent. Now these are some of the documents which are required for you to file. The first one, very important, covering letter. So in covering letter, you just mention like introduce yourself, then patent. I am applying for a patent, and what are the documents you are enclosing along with the patent. What are the forms you are enclosing. Everything should be drafted in your covering letter. Then application for grant of patent, that is form 1 is available. Then complete provision specification in form 2. Statement undertaking in form 3. Power of attorney form 26. Declaration of inventorship form 5. Request for examination, very important. We have to go for request for examination. Then only we get our grant. Then F18, form 18, we have to go. Then whatever the fee is levied on that, we have to pay the fee, statutory fee for that, either through check or DD. Okay. And I'm not telling that fee is filing. Minimum cost is only 1,500 to 1,800 rupees. It is fine. But when you go for examination, it costs you more. It costs you more. That's why your institutes have to support for you in for going for granting. For going for granting. So in India, the application we can any person claiming to be true and first inventor or inventors. That's why I said inventors in your lab can go for paid filing. Then any person being the assignee of person claiming to be true and first inventor. And they have to be proof for that. And once the proof is available, then we can go for patent. And the legal representative of any deceased person or the assignee is also eligible, for to file a patent. Just sorry, 1 minute. Okay. Then this complete specification, all of you know. Then main steps also I get. Now this is a grant in aid. How do you get a grant actually? First, you have to draft your patent, then go for filing process. And please keep in mind, all the forms are available in India Patent online website. Just just get those all the forms. Okay, get those all the forms. You try to fill all the forms, right? And then go for apply office or go for e-filing. So if you go for e-filing or patent office, whatever it is, then first it goes for publication. Okay. And publication, it may take up to 18 months. Okay. After 18 filing complete within 12 months after provisional, then if it gets yes, then go for publication. So immediately they'll get published, but don't stop there. Then after publication is done, you apply for examination. Then once you give request for examination form, it may take up 48 months from date of priority. 48 months it will take. That means up to 4 years also, 12 years. Up to, okay? So within 48 months, you can go for that. Now, once you have went for examination, okay, then once it goes for examination and they say yes, this is very good technically and applicability is there, then they'll give grant. Then grant will be issued on your name. Then once the FER is issued, okay, then application will be put, then grant will be given to you. Okay, when there is no objections met within 12 months, your grant will be given. Suppose when there are any objections from any of your co-inventors, then again it goes for re-examination. Okay, it may take 12 months to 24 months re-examination. Then after that, the controller will get the decision. Okay, then it goes for. Then if objections are not met within 12 months, your patent will be abandoned. So you'll not be granted patent. But once there are no objections, okay, when objections are met, so it's very clear. Now there are no opposition from the co-inventors or anybody, then the grant will be given within 12 months of your examination process. And post-grant opposition also can be raised, and see to that your inventors, your students or your faculty or co-inventors does not raise any post-grant oppositions. Okay, you be more clear on that. Now, these are some of the documents I've listed down, which is available in ipindia.gov.in. So there are fee documents are there. Then a grant of patent. I'll just show you these documents. Is the screen visible to everyone?
Yes, sir, it's visible.
Yeah, so these are the details of forms required to be filed under patent rules. Now, if you see here, as I mentioned, one application for a patent under section so and so. So natural person or startups or small entities or education institutions, because we all belong to education institutions, only 1,600 rupees. 1,600. And see, if there is a women participant in your invention, okay, you will get your patent very early than prescribed timings. Okay, you will get easily. So see to that when women participant is there in your research work patent. So 1,600 only. Okay. So for e-filing, other people, okay, can take up to 8,000 rupees. Then for physical filing, very easy, 1750, as I said, 1,500 to 1,800. So you take 1,750. But for multiples of, if you see others alone with a natural person or startups, okay, they will take up to 8,800. So these are some of the fee levied by government. Okay. So on filing complete specific, of course, up to no fee. Okay. For each claim, in addition to 10. Suppose beyond, addition to 10, suppose we are claiming more additional claims. So they are charging 320 rupees. Okay. 320 rupees. So like that. So they have a set of, rules for this. Then on request for extension of time, so we have 2,000 rupees we have to pay. Of course, we won't request time. On time, we have to submit everything, right? So these are some of the processes involved according to the fee schedules. Okay. So altogether, if you see getting a patent grant, I'm talking. So if you see all this, so it costs you around 1 lakh to 1 lakh rupees. So that means that the institution has to support a faculty, to get granted. So these are some of the rules. All these rules may not be applicable for us, but some of the rules, I mean, some of the fees what have been listed down can be seen. Now, similarly, if you see application for grant of patent, this is very important form. I'll show you. Now see, this is one. Okay. So where form one patent act. Now this is a grant application for grant of patent under so and so sections and sub rules. Okay. So now application reference type of application, please click. Or is it ordinary or a convention or a patent treaty you are applying? Okay. Or divisional, whatever it is. You have to apply. So you can go for ordinary patent. Then the name in full, gender, nationality, country of residence, age, you have to give, address of the applicant. So each applicant we have to give. Then category, is it natural person or other person? No, we are natural person. Okay, natural person only. The institutions can also apply. We can take education institutions because as education institutions can also apply for patents, we can apply. Then inventors, you can go all are inventors, same as the applicant name above. Yes, we can take this. Then if no, you can furnish the details of other inventors. Other inventors also you can make it, their details. Then give the title of the invention. Okay. Then authorized registered patent agents. If there are no patent agents, no need. So if there is a patent agent, you can give your patent agent name. Then address, you can give address of that applicant where you reside, everything details. Then in case of applicant claiming priority of application filled in convention country, particulars of convention applications can also be filed. So in case of PCT Act, if it comes in PCT or applying, you have to give international application numbers, the filing dates, everything in Patent Cooperation Treaty details. Okay. Then these are additional sections, declarations you have to give. So these are declarations by inventors and declaration by, conventions. Sorry. Sorry. Then declaration by inventors, declaration by applicants in convention country. This is not necessary for us. Then declaration of applicant. Yes, we have to give declarations. All the details, please read carefully and tick in the box, check boxes before you submit. Okay, then following are the attachments with the application forms. What are those? If you see the complete specifications, number of claims, see to that up to 10 only, because if you cross the 10, Again, you have to pay additional fee on the each claim. Each claim you have to pay 320 rupees. Then abstract, yes, number of drawings, that means number of tables or illustrations, whatever is there, you give 3, 2, 4, 5, whatever it is. The number of pages, number of claims, and number of pages, okay, number of drawings, etc. you have to give. Then the respective fee, whatever they levied by the government of India, that fee has to be included here. And any remarks are there? Nothing, no remarks, not applicable. Then you have to go for total fee. You have to draw you can go for check or a DD. Then you have to submit. Okay, declaration and submit. So this is as simple as that. Okay, application is simple. Only thing is about to go through it carefully, meticulously fill the details and submit in your patent office or even e-filing as well. Now, if you see this one, uh, these are the complete specifications. I'll show you complete specifications as well. No, this is what form 2. Okay, title of the invention, your application, provision or complete, then description. Description shall start from next page actually, because this is the government given. So what we can do, we can retype it. So we can type again and we can make it, we can send it. Okay, then claims, abstract of invention, etc. So this is what a complete specification involves. And then undertaking, I'll show you undertaking forms. So this undertaking, I think form 3. So name of the applicants, address, name, address, and nation of joint applicant, everything got to give. Name, country, application number, status, everything. The name, address of assignees. Okay, to be signed by applicant or is authorized patent agent. So when there is no patent agent, just directly we can give. The name of natural person, then is same thing. To the controller, patents office, Chennai, we have to give, or at Kolkata, at Delhi, or at Mumbai. So these are some of the application forms. Now see here, oppositions, all these forms are listed down. Okay. And I'll show you request for examination as well. Hmm. Yeah, request for express interest, request for examination. Yes, this is what very important for us. This document we have to request. So this is the form 18 depicting, a request for examination, because I don't restrict myself to only, publication process. We move on to the grant. So that is what grant. So yes, to thoroughly examine my application, please give me grant. So this is application. So showing the name, nationality, statement, we give the statement of request for examinations. Request my application patent number so and so filed on PCT or application number, made in country India or made in country somewhere, etc. shall be examined under section 12 and 13 of Act immediately without waiting for expiry of 31 months as specified. Yes, immediately. Yes, go for examination, and within 12 months or 14 months, you will get your grant. So this is for address of service. This is application showing examination process. I hope it is clear, that filing process. Now we can go for licensing also. And now once the patent is granted, then you go for commercialization process. Now is this visible? Commercialization visible to everyone?
Yes, sir, it's visible.
Yeah. Now, once the patent is granted, it may take 2 years or 2.5 years. Fine. So within the 2.5 years of span of time, then once you get the grant, don't keep then the patent with you, because the patent is always on your name. Fine. Then we have to go for commercialization. Now, of course, we have different one licensing, we have selling, we have etc. Okay, but I tell you what is commercialization and all. Now this commercialization actually, it's a dynamic process where you are transforming your invention. Okay, where you're transforming your inventions into a tangible products. Okay, or a tangible service from which you can generate revenue. You can generate revenue. Fine. Whatever may be the stream, it can be a commerce management, it can be life sciences, or it can be computer science, or it can be some other areas. Okay. Now, these are the four key elements involved in commercialization process. The first one is the patented invention. What the patented invention, mm, uh, deal with? So this is nothing but, you know, invention or the IP, intellectual property, that have been granted the patent protection. Patent protection. So your patent already granted. Now we have to go for commercialization. So this patent inventions, this commercialization, it revolves around your inventions, which can protect your patent, the granted patent. Okay, where it gives your exclusive rights to allow them, okay, to allow them to, how your patent can be, uh, what I say, utilize, or your inventions can be used in other patents. Suppose you have a patent, how can I use your patent? That comes under patent invention commercialization. Then comes transformation. What this transformation involves? So this commercialization, this concept of transformation involves, that uh, taking patented concepts and converting them into marketable or some useful product. That is what transformation. So take your patent, and the process or patent can be, we can transform into practical way, or which can be useful in marketable way, so that you can create more business opportunities. More business opportunities. Then coming to marketability. Yes. So what is the ultimate goal of commercialization? So revenue generation, nothing but revenue generation. So the marketability should be there. Suppose I made a product, so and I want to bring it to market. Suppose if that is uh, not suitable for marketability, so I can't generate revenue on that. That's why make first to transform it so that it's suitable for marketability, and proper revenue can be generated on that commercialization. Now, what is significance of commercialization? There are 10 aspects of significance. How we make. The first one is the economic growth and also job creation. So this economic growth, the commercialization, when you commercialize, okay, that commercialization might gives rise to, giving more development, increase or enhance development of new products in the market, development of new businesses in the market, development of new services in the market. In turn, that reflects our economic growth. Okay, that stimulates economic growth, and that creates more jobs in the market, more markets. Then coming to know the returns, or what we call, suppose you are investing on your product, so we expect some returns on it. Okay, so that investment is possible only through commercialization, what we call ROI, returns on investments. So that is possible only through commercialization. Suppose I have patent, I'm not commercializing it, then there is no return on it. Okay, you have to look at ROI also. Then competitiveness, or we can say competitive advantage. Like these patents, they offer competitive advantage. Okay, so that rights are being granted, and that rights are restricted to your technology only. Then what happens? Then competitive starts. So once you have developed a technology, and that competitive, okay, that person has did something, so I should do improve the technology. Then I start working on the technology, I try to improvise that. So this is a competitive advantage. Then comes to technological advancements. Yes, obviously technology advancements is through commercialization purpose. Then funding and investment. Okay, so the revenue generated, okay, can attract more investments and more funding, and more you can bring out more venture capitalists also to attract funding on that. Okay. Then next one, you can contribute to market expansion as well. Market expansion. So this process, when you commercialize a patent, you can enable the business process. You can enter into market, and you can expand the market locally first, then state, national, as well as international as well. Then, of course, knowledge sharing is always there when you commercialize. Knowledge sharing will always be there. Then coming to IP protection. So yes, you can protect your IP so that nobody can misuse your product or a process. Obviously, consumers get benefited, and that leads finally leadership is very important. So you're going to standardization, and you can increase, you can create the leaders in the market. You can become a leaders. Okay. Then what are the different strategies for our commercialization? So there are different strategies available. The first one is licensing the patent. Second one, selling a patent. Third, in-house product development. Fourth one, collaborative ventures and spin-offs and startups. These are some of the strategic planning we should be keep in mind before going to commercialize your granted patent. Now, see the second one, selling patent. Most of the people, I mean, some of the people, not most, some people commit mistake selling the patent. Okay. We should not sell any our patents to anyone. We have to keep in mind only we have to give license. That's all. I got my license. I am giving a license to you so that we will be getting royalty on that. Better never sell a patent. I've depicted here only because it is one of the strategic plan. Okay. Now coming to licensing a patent. So licensing, it involves, the individuals or the business people. Okay. The right to use, to make, or to sell. Okay. Or even we can distribute also the patented process or patented product or the patent technology. Okay. In exchange of royalty. In exchange of royalty. Right. So in exchange of royalty, that nothing but you will get a fee. Okay. Suppose you have a patent, you are licensing to me. I'll pay royalty to you. So every on my profit, okay, I'll be paying royalty. And for this, we have to sit with the industry people and start negotiating. So they start negotiating. So much of percentage of royalty should be given to me then only I can license to you. Okay, this is what. So where you can develop my technology, nothing but technology transfer, what we call. Okay, you can go for develop or manufacture my product using my technology, my technology. So this type of licensing is no, it is very common in industries like technologies, like when you're going for small startup companies. So we can they take up the licensing from some other already existing technological aspects, and they do startups. So this is called licensing. Then universities or our type of education institutions where we are working, we can also license their patent other innovations. Suppose some technology is already there existing, you can approach them, you can ask for technology transfer, you can ask for licensing for us, and best method I am talking, get the license and start your incubation center. You can start the product making, and you can make your marketing, because already you are applied for licensing and you already paid to them, and or you already, I mean, once you sell the product, you will get some profit in that, you can distribute, give to them. So our colleges or institutions, universities, what we can do, better incubation center, not like we like rocket science, we should invent something else. You can go for technology transfer, ask for someone else, you pay the money, get the technology, start in a college or university, you start producing the product, incubate, that is called incubation. You can go for your commercial, I mean, into market. We can do like this. Now, next one is selling the patent. Selling, actually selling, that means we are transferring our ownership to someone else. That is what we should not do that. Okay, we should not do that. Suppose once you do that, you will not get any royalty on that. Licensing in the sense, we'll get royalty throughout the period. Suppose my product I have, I'm licensing to you, one of the person, okay, industry person. So I give license for say 10 years. 10 years, I'll be getting royalty for me from industry. How much amount profit they make, that much percentage more I'll be getting. But selling in the sense, I can sell the patent. Selling again, negotiate. You will be getting only minimum amount of amount on that selling a patent. They'll not give some crore of rupees, one CR. They'll not give. But if you license, you'll get a lot of money, because that licensing amount royalty, that depends on the profit of them. So that you have to negotiate such a way, on the profit, some percentage they have to give as a royalty. Then you get more amount. You can generate revenue through your patent. Okay, then 1 minute, sorry. Then the third strategy involves the in-house product development. Yes, once you get a grant, no doubt you need not license to anyone, and you need not sell your patent. You can start your own startup, or you can start your that small technology in your institution, and you can develop a product and try to enter into your market. Then collaborative ventures. Yes, you can collaborate with someone, and you can start producing the product, and you can enter into market by selling. And spin-off and startups, of course, all of you are aware of this. You can create your spin-offs or startups, okay, which involves your establishing the new independent businesses. You can start your own business, and you can commercialize your products, or you can commercialize your technology. This is spin-offs and startups. But mostly what we do, we license, or some people, they sell the patent because they want immediate money. They want to make money. And most of them, some people sell the patents, but licensing is preferable than selling. And of course, in-house product development is always good, but provided you should have funds to establish that manufacturing process or the utilization of technology, how to develop that. That is very important for in-house product development. Then, of course, these are some of the factors that affect your commercialization. One is market research and demand. Suppose when there is no demand, that will definitely, cause obstruction in, selling or, getting money on that. But that's why market research and demand is analysis is very crucial. Okay, you can understand first. You have to understand what is the market demand, what is size of the market, who are the customers, potential customers for your product or process, and who are the competitors for you in the market. This all dictates your product in the your market stand in the your market. Then second one, TTOs in the sense technology and transfer offices are also there. Technology and transfer offices and incubators are also available. So incubators. Okay, so we have technology transfer offices in certain universities and research institutions. And we have business incubators, technology business incubator, TBI, what we call, we have established in certain universities. And these TTOs or incubators, they also play a crucial role in commercialization process. Now, because they facilitate your transfer of technology. In transfer of technology, they facilitate crucial role. And they also, these incubators, they provide support, in the form of money, resources. They provide resources, and they give conducive environment to you to initiate your startup in your university or institutions. Then third one, industrial trends, and that's why competitors, I said, there are competitors in your market. So that has to be analyzed before entering into commercialization and further market levels. They have to update. So what is the recent updates available in the industrial trends, how they are moving, and what are their strategic plans in the market, and how best we can enter the market to grab that market potential customers to us to sell the product. Then next one, legal and regulatory considerations. Of course, there are, there all the patents we have, they are subject to legal considerations and regulatory considerations in compliance with IP laws, okay, and maintenance laws that we have to oblige, and we have to get into this part. Then we have patent valuation process also. Patent valuations. So where suppose my patent is granted, and suppose I want to commercialize, because I want to license to industry. Okay, I want to license to industry. Now, industry persons are very smart. They will not take our patent as such. Once we sit and discuss with the people, they start evaluating our patent. So there are methods. This is a process industry people have. So this process involves, they try to estimate or determine the value of our patent. Okay, based on the cost, based on the market, based on income, and also replacement cost. Okay, so based on these valuations, then only the industry persons come to us, call us for a meeting for next level of licensing process. Okay, so based on cost, so assessing the cost incurred in obtaining and maintaining the patent, so that can be evaluated. Then market based, whether this is market suitable or not. Based on that market, whether it's efficient and the price is competitive, then only the license can be, we can apply. Then income based, whether suppose if I get into a market, whether I can generate income or not. Then the last one is replacement cost, because estimate the cost to replace the patent with alternative technologies, whether it can be replaceable or not. Based on that also, they can evaluate your cost. Okay. Then how to determine whether your patent is worth or not? Very crucial point. I have a patent, fine. I've granted, but whether my patent is worth or not. Worth in the sense, not I'm talking about the concept, what I my research. My research is worth. That's why I got a patent. But how whether I can get into market commercialize or not. That is very important. So for that, first you have to do assessment. The first one is technology based assessment. You have to assess the technology, whether the technology involved in your patent is unique, relevance, relevant to the present scenario, and it is applicable. It has potential applications in the market. Okay, so whether your patent is presenting cutting edge technologies, that is very important. Then only you can go for commercialization. Otherwise, need not go. Don't not necessary, unnecessarily. Okay. Fine. Next, position the market. So the the patent, what you say, best word is portfolio, because I'm not a commerce student. That's why I'm feeling some words in commercial listing. Patent portfolios, market position when you see. So how to capture the present market scenario? That is very important. Okay, how to capture whether your patent has that potential to capture the existing market is very important. Then only you can go for commercialization. Then next is market cost. So how much cost incurred for you to to produce your product or whatever it is, and you should get more than that. Okay, so you have to maintain, of course, not neck to neck, but no loss, no gain. In the worst condition, no loss, no gain, fine. But always look for a profit. Otherwise, need not get into marketplace. Then geographical reach. So what is scope of a patent? Whether you can reach all the geographical areas within India at least, all the states at least, or your product is restricted only to Hyderabad, only to Mumbai, only Delhi. That is best. That is best. Ensure that your product is reachable to and across the country first, at least national level. Of course, international if you can reach, well and good. At least national level. Then try to commercialize it. Then finally comes expiration date. Lifespan of your patent is very crucial because I said 20 years. 20 years. Okay. And the patent which is coming close to expiration have very less value. Very less value when compared to those already have almost 20. Suppose my patent is having say 19 years of now, 20 years, 1 year over now. Okay, fine. 19 years. Some other person patent is having 10 years. Some other patent has 2 years. So the 2-year expiration date is almost coming close. That patent has very less value when compared to my patent. Now this is how we can make our or not. Then based on this, yes, go for SSO technology. Try to read out research, position the market, how to grab. Then cost you have to costing you can make it. You have to reach across the India and expiration. Based on that, decide whether your patent is worth or not. Yes, when my patent is worth, then get into commercialization. Go for industry people and try to negotiate with them. Now, what are negotiation? Here we have licensing and selling. The only two are there. Whether you can take license or you can go for selling. As I said, licensing, licensing normally is better way than go for selling your patent. So licensing, start negotiating with them the percentage of, royalty, how much they are going to give you. Okay, what is the rate of percentage of that? Okay, and what is the duration of your agreement, whether it can be 5 years or 10 years, whatever it is. Everything you can negotiate with industry people. Okay, based on that, decide if it is working out better, then go for licensing agreement and sign on that, and industry people will sign. Okay, then every year you'll be getting, you can revenue royalty on your patent. Then selling. So you are almost, I know it's almost selling, but selling is not advisable. Okay, in this patent, because you're already selling your patent. If some people, if you're interested in selling a patent, just ask them how much amount they are going to give. If they give 1 CR at a time, fine, you can grab that. You can start up your own like that. Your startup is not on that, because you're selling patent means everything rights you are transferring from you to the industry people. Now you cannot work on that patent again. There are no rights for you. You're only licensing. You can start, but license only given to him. Okay. So that's why better don't sell your patent, go for licensing your one. So these are some of the concepts involved, and these are the future trends. Future trends, in commercialization. It may come because now we have artificial intelligence, we have machine learning, etc. It is technology driven. AI ML is involved, data analytics is involved. Okay, so we are using AI ML technologies, data analytics in evaluating a patent, calculating the worth of a patent. Everything is now AI ML based and data analytics mode. Okay, so and how the market is available in the present scenario, everything will be given in a technology driven way. Now, other one is market positions, the blockchain technology is involved, uh, smart contracts. Okay. Then smart contracts so where the blockchain technology is embedded or enable blockchain technologies, where the licensing agreements are automated and the royalty payments are also being automated. That is what smart contracts. Everything is automated. Then open innovations and collaborations. So cooperative R&D agreements we can make. Okay. So like we call cooperative R&D agreements. Then we can also go for open innovation systems. So cooperative R&D agreements involve government agencies. Okay, so we can collaborate with, we can foster collaborations with the private institutions, private universities, research institutions, etc. for further development and commercialization of your product. That is all cooperation. We can tie up with someone else and we can start producing a product and we can commercialize our product. Then open innovation platforms, where companies are now, they're topping up like anything. Now these companies are increasingly what they're doing, they are turning into these open platforms, open innovation platforms. Now these companies are coming, to inventors and or they're partnering with inventors and startups, and they are uh, 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 doing this patenting process, manufacturing process. Okay, like they're negotiating the terms with partnering startups, and they're sharing the patent technologies and starting their innovation process. That is called open innovation platforms. So these are the future trends, and fine, better, because we have to go through these technology driven. We have to go well with the market driven. So these are some of the technologies involved, future trends, and I thank these organizers for giving me the opportunity to present a brief insight or overview of drafting, filing, and commercialization of patents.
Participants, if they have any doubt, please raise your hand. I will give the mic access.
Yes, participants, if you have any doubt, you can raise your hand.
Good afternoon, sir.
Two, yeah,
I,
yeah.
I,
Good afternoon,
I'm
madam.
really impressed and thank you very much for giving a full depth knowledge about not only the patent filing but the post process of commercialization. And the only query is any agency that deals with such commercialization, because we academicians find it very difficult to leave our job and go find industry and talk to them. So searching industry itself is a difficult task. So any agency like patent agents that deal with such commercialization process.
As of now, we don't have any agents, ma'am, to identify the industry collaborations. But we can approach any of the industries which are involved in the specific area in your area or in your research area. Then we can directly contact with them directly.
Okay, okay, sir.
There are no
It was
specific
very
agents
wonderful.
for it.
Yeah, yeah. Very knowledgeable and very innovative talk you have given. It
Thank
was
you,
a very
ma'am.
satisfactory. Yeah.
Dr. Nagesh Kumar. Dr. Nagesh Kumar has raised a hand. Madam, please unmute himself. Unmute.
Yes, the mic access is given to all the participants.
Okay. Nityananda Ghosh.
Hello.
Yeah, yes, sir.
Professor.
Sir, tell me, sir.
Just I want to know how long this patent lasts from the application filing date, sir. And designing a patent lasts for how many years, sir? And what all items that cannot be patented, sir?
What items cannot be patented? I have already shared with you.
Acha, acha, okay, okay.
Anyway, I just you can see. One second.
What are minimum fees, sir, for filing a patent, Professor?
Sir, minimum fees is 1600.
Oh,
And if women participant is there, there are more chances for you to get a patent. Easy.
okay, okay. Is there some fixed, organization or any agency that we can apply, Professor?
Yes, sir. Patent agents are available across India. So you can approach patent agents because patent agents, they're available at various patent offices. So you can approach them and you can take their guidance in drafting as well as filing.
But how to know the genuineness, Professor, that after paying money or something, is there any?
No, sir.
Op-
Actually, these patent agents, as recruitment is done only by Indian Patent Office.
Oh. Can you share us some patent agency names or some phone numbers? Can you share, Professor? So
I
that we
gave,
can.
sir, there are Indian patent offices. We have one in Chennai, Mumbai, Delhi, and Kolkata.
Acha, acha. Okay, okay.
These offices, they have patent agents also. You can contact your nearest office and you can request for assistance for drafting as well as filing. They'll help you in that.
Because nowadays in WhatsApp, so many people are, they are sending messages that pay this much, patent can be done like that. So how to
That is
keep
what,
them?
sir. I mentioned in my talk when I was talking. WhatsApp messages, so many, and even mails also coming. Give 20,000 rupees, first order, second order, 15,000, like that.
Yes, yes, yes. So
Please don't,
they are
please don't
fraud.
fall in prey of those people because they will give
uh,
only patent publication.
Acha, acha, acha.
And for that patent publication is not valid. We won't consider it. Even NIRF won't consider, NAC will not consider.
Okay, okay, okay.
Simply as our manuscript publication only, that is also same, but we are calling as patent publication. That's all.
Sir, Hyderabad, any
Sir,
offices are there, sir, for patent filing?
No, sir. Hyderabad, we have to approach Chennai office because nearby to Chennai.
Chennai, okay.
Sir, just 1 minute, I will interrupt. You said about women participant or women person applying for
Yes, ma'am.
patent. So I will share my experience. I had applied for my first patent and it was
Okay.
on anti-convulsant agents. So I applied through one lady patent agent and
Hmm.
on the day of examination, just 2-3 days before she got seriously ill with meningitis and she was admitted and I came to know that she has lost her hearing ability. Then it
Okay.
was only me, so I had personally attended the examination hearing, and the person who was examining me was organic chemistry person, and I being organic chemistry, he could understood every mechanism that I had explained, and in one hearing, he was very satisfied, and I could get my patent with that.
Oh, congrats, madam. Congratulations.
Yeah. The second one, then I went through the agent only. So there also
Hmm.
I had a woman a student with me, my PhD student, and that was also a successful patent process as well as product.
Very nice, madam.
Yeah. So and we get all
Can you,
information on agents and on the Google we have all information available. So we can make use of that. And now even the fees is reduced. When I filed, it was a heavy fees. Now
Yes,
after
yes.
this government, they have reduced for academicians.
can you,
Academic reduced, but post patent, you have a lot of money, madam.
Yeah, I
For
have to
maintenance
renew
cost, you have
every
to
year.
pay.
Yeah, yeah.
can
Yeah.
you,
Every year I'm renewing it. Yes.
Yes.
can you share some phone numbers, madam?
Sir, you can find on whatever your city, na? So you can find out any agent in Hyderabad. Because coming to Bombay or discussing with a Bombay person will not be feasible for you. So
Full
there are
feasible,
patent.
correct.
So you can find anywhere which is nearest to you, and so you can discuss with them. You
Okay.
can discuss with 2-3 people and then decide.
Sir, you can
Okay.
discuss with 2 or 3 people and find out genuinity of those agents. Otherwise, don't submit your application to them.
Okay, Professor. Okay.
Yeah.
Thank, thank you so much, Professor. Thank you.
Thank you, sir. Thank you. Thank you, ma'am.
Okay. Anyone else to ask anything to sir? No one. Okay. Thank you, sir, for the wonderful session. As we conclude this enriching 5-day national level faculty development program, I would like to extend my heartfelt thanks to everyone who made this event a success. And on behalf of the Department of BSc Computer Science of Nirmala Memorial Foundation College of Commerce and Science, Maharashtra, in collaboration with Loyola Academy, Telangana, a special thank you to our esteemed speakers for your invaluable insights and expertise. Your session have been truly inspiring, and we are grateful for the time and effort you invested in sharing your knowledge with us. We deeply appreciate your precious time and contribution to the success of this national level FDP program on enhancing quality research through patent writing and IPR. And to our attendees, thank you for your active participations and enthusiasm. Your engagement made this program all the more meaningful, and I'm confident that the lessons learned here will have a lasting impact on our professional growth. So finally, a big thank you to the organization also for conducting such an amazing and enthusiastic 5-day national level FDP. We appreciate everyone's contributions, and we look forward to carrying forward the knowledge and connections from these 5 days. Thank you once again, sir, and wishing you all the best, everyone. And the e-certificate will be provided to all the participants through WhatsApp. So within a 15 working days. So don't leave the WhatsApp group. It's provided by WhatsApp only. Thank you.
Thank you, madam. Can I leave?
Thank you, sir.
Thank you.
Ma'am, the feedback form that you sent, it is not accepting any feedback.
Sorry, sir, what
Hello?
you are saying?
The feedback form that is sent, it is not accepting any feedback.
Okay, sir, we will resolve it.